So joining us today from The Hague in the Netherlands to discuss about judicial procedures in the International Criminal Court, ICC Spokesperson and Public Affairs Unit Head Dr. Fadi El Abdallah. Thank you for joining us, sir. My name is Zen Hernandez from ABS-CBN News here in the Philippines.
Thank you for asking.
All right. To start off, sir, the situation with former President Rodrigo Duterte has become a huge political issue here in the country and even there in The Hague. And I suspect you've seen, or at the very least heard, about the show of support from his supporters there in The Hague, from the detention center to the ICC headquarters. And I believe even the judges are currently seeing an increase in activity on their social media pages. So I'm just wondering if there are concerns of these activities interfering with ICC's process, and will this have any bearing on the case or how the judges would decide on anything?
But it's important to highlight that the judges would only decide based on the legal applicable rules and based on the evidence that is submitted before them. So anything that is outside of this framework and outside of what is presented to them by the parties and the participants to the proceedings are, by definition, issues that cannot be taken into consideration by the judges and would not have an impact on their decision in relation to the charges. It's important to highlight that the judges are impartial. They have all the guarantees that are necessary to ensure that they will be only applying the law and will not be under any kind of influence. The judges have all the necessary guarantees to ensure that their decision will only be based on the law and on the evidence. And we fully understand and respect the different people's views on the proceedings, but we all have to respect the integrity of the proceedings and leave the judges to decide on the matters, because they are the ones who are professional, who have a long experience in dealing with complex legal matters.
I believe this is the first time that the ICC has experienced this. So how does the ICC actually manage political pressures or even attacks?
It's, as you said, before the ICC, there has been several other cases with very high profile suspects. And the work of the ICC has to always remain impartial and based on the law and on the evidence. So we do understand that we do not live in a world where there is no politics, of course. But the work of the justice and the work of the judges and the work of the ICC as an institution is precisely designed in order to avoid any kind of influence or interference of any extrajudicial matters in the work of the judges, who can only decide based on the applicable rules and on the evidence that is available.
Now, the camp of the former president is questioning the 43 cases used as basis for his charges and even the arrest warrant by the prosecution, saying it is a far cry from the allegations that there were thousands of extrajudicial victims during his administration's drug war. So I believe it is important that we go back to the basics for the benefit of all who does not have legal expertise to know what the crimes against humanity means and what actually constitutes such a crime, sir.
Duterte is charged with the charge of a murder as a crime against humanity. A crime against humanity is a category of international crimes, like genocide, like war crimes, and like crime of aggression. These are the four categories of crimes that may be under the ICC jurisdiction under specific conditions. For the crime against humanity specifically, it's required to be conducted in the context of a widespread or a systematic attack against civilian population. So there should be a kind of a plan that is prepared and organized by either the organization or becomes a state policy that includes a widespread or a systematic repeated attack against civilian population. And then different conducts may qualify as a crime against humanity. It can be murder, it can be torture, it can be rape, it can be other types of illegal conducts. But when they are conducted in this context of widespread or systematic attack against the civilian population according to an agreed on or common plan, then we can qualify that as a crime against humanity. You mentioned the 43 incidents that have been used for the purpose of the arrest warrant. Now, this doesn't mean that these are the only incidents that may be included in the charge. These were a sample of incidents that are related, that were for the purpose of issuing an arrest warrant, sufficient from the point of view of the judges to sustain the charge of a murder as a crime against humanity for the purpose of an arrest warrant, which is the first step in the judicial process. The next step, which is the confirmation of charges hearing scheduled in September, would look deeper and after hearing also the defense to decide whether this case should go to a trial or not.
So the prosecutor is allowed to bring in more evidence, more witnesses, more victims?
Yes, the prosecutor may submit to the judges additional requests, and eventually it will be for the judges to decide whether they can be admitted or not. In the meantime, we need to understand what is going to happen between now and September, where the confirmation of charges here is scheduled. And for that, we need first to understand that the confirmation of charges hearing is not the trial. It is a pre-trial phase, after which the judges would decide whether or not there would be a trial, or if the case will stop at this pre-trial stage. Now, the purpose of the confirmation of charges is thus to test whether the prosecutor evidence are sufficient to go to a trial, or if the case should stop earlier. And for that, the prosecutor would have to demonstrate to the judges, taking a certain sample of evidence, that these evidence are strong enough. But we have to respect the rights of the defense, meaning that the defense should have the time and the facilities to prepare, to respond to this evidence that may be proposed by the prosecutor and discussed during confirmation of charges hearing. So before the confirmation of charges hearing, the prosecutor would have to disclose, so to transmit to the defense, the evidence on which he intends to rely during the confirmation of charges hearing, so that the defense would have the time to study it, to examine it, to counter-investigate certain elements, to prepare its own submissions to the judges. And that's why we have this time between now and September, so that the prosecutor transmit these elements to the defense, and then the defense would have enough time to work on it. In addition to that, the may authorize victims to participate in the proceedings through a lawyer, which is what we call the legal representation of the victims. So they are then become participants. They are not parties. They are not bringing charges or bringing evidence to the judges, but they will be allowed to present their observations, their views, including on the legal questions that are discussed, and also express their own stories to the judges. So this is what is planned between now and September. The confirmation of charges hearing itself is only a matter of few days. Usually it's a presentation of a sample of the evidence, not all the evidence that may be discussed at a trial if we go to a trial. And of course, the prosecutor may or may not call a witness, same for the defense. But if witnesses are called, the other party would be able to cross-examine them, of course. After the hearings, which may be a couple of days, 2 or 3 days, normally, or 4 days, after that, the judges may or not give additional time for the defense and the prosecutor to present in writing a kind of complement to what they have already discussed. And then after that, there is a period of 60 days, which is the maximum time within which the judges would have to issue their decision whether to confirm or not the charges in total or in part. And if none of the charges is confirmed, then the case would stop at the pretrial level. If one or more charges is confirmed, then the case can go to a trial. And of course, both the prosecutor and the defense, they may leave to appeal, directly appeal it, need to first be authorized to appeal if they are not satisfied with the decision.
So as we speak, there are actually like families of victims here in the Philippines who are still trying to decide whether to participate. They're basing their decisions, of course, on the developments, on what they see. Of course, they have security concerns. What will be the procedure for those people in case they would like to join in the case? Can they join in this process that we have?
Well, yes, but we need to clarify for them the difference between participation and asking for reparations. These are two different processes. At this moment, we are not speaking about reparations. The courts do not discuss the issue of reparation unless a person is convicted after a trial. And then we can discuss the issue of reparations. But before that and until that, we are only speaking about victims' participation to present their observations, their point of view, and their personal stories to the judges. And this participation is free of charges. They are not receiving reparations as part of the participation. As I mentioned, this is a separate process, but they also don't need to pay to participate. It's totally free of charge. And they are participating through a lawyer, which is what we call the legal representation of the victims. Normally, there is a form that has to be filled to indicate whether they are victims of the crimes that are part of the charge. So it's not... I mean, if people are victims of different crimes than the one that are in the case, they cannot participate in that specific case. And that's why there is a specific section at the ICC, which is called the Victims' Participation and Reparation section, that works with the victims, with NGOs or lawyers who are representing them on the national level, in order to help them understand and facilitate the process if they want to participate, which is totally their right to decide to join or not.
Right. And should they decide to join and participate and are willing to testify and all, but have security concerns, can they hide their identity? Are there security protocols in place?
Well, yes, but it's important to separate the two issues. When we are speaking about victims' participation, it's only to present their observation and their views. It's not as witnesses. Witnesses are individuals who are called either by the prosecutor or by the defense to testify. And they may be victims, but they can also be experts, or they can be insiders, or there can be different types of witnesses. So not all witnesses are victims, and actually only a very minimal number of victims may be called as witnesses during the proceedings. So we're speaking about two different things. Participating as victims and being called by the parties to testify is two separate things. And of course, the witnesses are protected. There is a program of protection for the witnesses. And for the victims, there are different sets, but they are not witnesses, so their exposure anyway is much more limited.
Now, going over to the legal defense team, they're saying that they're hoping to present jurisdictional arguments on behalf of their client. And if I may quote the lead counsel, he says that there is a compelling argument for the lack of ability to exercise jurisdiction given the Philippines' withdrawal from the Rome Statute. I know you have responded to this. It's been an issue since day one, but can you just react again to this statement?
First, I'm not familiar with what exactly the defense lawyer have said, and if he has a specific request, it would be for the judges to decide on it. But I can speak in general. So not specifically about this case, but in general, the ICC judges have decided in previous decisions in relation to Philippines and in relation to Burundi that the ICC has jurisdiction over the crimes that were allegedly committed during the period when the state was party to the ICC Rome Statute. So a withdrawal does not affect the crimes that were allegedly committed before the withdrawal became effective. So the ICC retains jurisdiction because it did have already this jurisdiction when the Philippines were state party to their own statute. Now, a withdrawal only affects the future, so meaning that the ICC would not have jurisdiction for the future after the withdrawal became effective, but not for the crimes committed allegedly during the moment where the Philippines were still, back then, a state party. This is the jurisprudence of the ICC in relation to Burundi, and also it was mentioned in relation to the Philippines when the judges authorized the prosecutor to resume the investigation.
And if ever the defense team would present such an argument, what will be the process for this? Is it something that will be heard separately, or is it something that will be discussed at the confirmation of charges hearing on September 23?
Well, I think it's for the defense to decide. First, as I mentioned, I don't know what exactly might be their request, whether it is actually this related to this general question or it's related to something that is very specific to the case, and then it will be for the judges to decide. It will be also a matter of the timing of the request of the defense itself, and then the judges will decide how to sequence these questions.
And then in relation to this, of course, the camp of the former president has been questioning the Marcos Jr. administration's cooperation with Interpol during the arrest and turnover of the former president. So can arrest issues also affect any case? In short, can it cause the dismissal of charges based on historical facts? Yeah.
I would not speculate on this matter because it might be subject to a request by the defense before the judges, and I cannot prejudge what the judges may decide. So if there will be a request to that effect, it will be for the judges to consider whether or not it was a lawful arrest and whether or not that would have an impact on the ICC proceedings.
And the former president is also hoping to get back to the Philippines because he is running as mayor of Davao. So his lawyer also says that they will be making an application for interim release at the appropriate time. May we know also what are the basis for granting an interim release? What is the process, and what are the factors that we need to be, or the court needs to consider?
Well, again, I would not speculate on what might be the outcome of a defense request. I can just speak about the general legal framework of the matter. When there is a case before the judges, they have to decide whether it would be sufficient to issue a summons to appear on a voluntary basis, or if the arrest is actually necessary. And the arrest is necessary normally either because it's clear that the suspect might not cooperate with the court and might stay at large and not be present before the judges, or because he might continue or she might continue to commit crimes under ICC jurisdiction, or because the judges consider that the suspect might be creating obstacles or putting the investigations at risk if he or she are not arrested. So this is the general framework. Now, of course, a suspect is presumed innocent unless and until after a trial there is a decision beyond any reasonable doubt about his or her guilt. And that's why, as a person who is presumed innocent, there is a possibility for an interim release, even after the issuance of an arrest warrant. But for that, there will be a need to convince the judges that this person will be cooperating with the court, will be present before the judges at the moment when they order his or her presence, will not be creating obstacles for the investigations, and will not be continuing eventually to commit crimes. And of course, if there is a decision towards an interim release, it might be also a conditional release, meaning that the judges will be imposing specific conditions on the person, but also asking the state in which he or she may be released to accept the release, but also to accept the implementation of a set of measures that may be designed in order to ensure that this person will not run away, will be present before the judges, will not endanger the investigations, and will not be committing any crimes during this interim release. So this is a general legal framework. And as I said, I was not speaking about a specific case, but only about the general rule.
Yes. And then a state, you mentioned the state needs to accept it. Can it be any state? Which state is this? Can a state like the Philippines actually say, tell the ICC, oh, send him back to the Philippines, and you can release him here?
Well, again, I will not speculate. This becomes a specific case, and then I would leave it for, of course, for the defense to eventually to submit the request, and then we see what the judges would decide on.
The reason I'm asking is because I'm wondering whether this is only allowed in ICC member states. Or is it?
It will be for the judges to decide eventually if there is a request and to consider whether it would be appropriate or not.
I'm just wondering also how the withdrawal of the Philippines as a member state in the ICC would also affect in case of a conviction. We're not trying to preempt it, but we're just looking at what could happen if in case of a conviction. Does that mean that he cannot be imprisoned also in the Philippines, being not a member state? Are we correct in thinking that?
I think it's really... Yes, I think it's really premature to discuss these matters. First, the suspect is presumed innocent, and we cannot speculate that he will be convicted or not. First, we need to see what the judges will decide about the confirmation of the charges, and then whether there will be a trial or not at all. And after that, if there is a conviction, what type of sanction. So it's really premature to discuss this question at this moment.
All right. The former president's team is also seeking legal aid, according to the family. Can you tell us what the conditions are for getting a legal aid from the ICC courts?
Well, in general terms, of course, all suspects have rights before the court, including the right to be presumed innocent, the right to remain silent without the science being held against them, and also the right to dispose of the time and the facilities that are necessary to prepare their defense in a meaningful and effective way. And if the person does not have the financial resources for that, in order to be able to secure a defense team for the period of the proceedings, then the ICC has a legal aid program that can be used in order to cover, in part or in total, the legal representation of a suspect. And it's actually the same legal aid program that is used as well to cover the costs related to the legal representation of the victims as well, because the victims also have the right to participate to the proceedings and to have a legal representation. And if they don't have the financial resources, then the legal aid of the ICC can be used for that. So, of course, the court conducts a kind of a financial investigation to check what kind of resources are available to eventually to the suspect, and based on that to decide whether or not to include him or her in the legal aid program.
Does the court have that capacity to actually investigate on all resources of a suspect?
Well, the court has financial investigators who work specifically on this matter, and of course, the work is as well in cooperation with the different states in which a suspect might have different assets as well.
And then also we have a former official who is there in The Hague, who is seeking asylum in the Netherlands, but who is also offering to represent the former president in his ICC case. Does the court have any rules on lawyers with possibly like warrants of arrest in their country? Although this is a warrant of arrest from the House of Representatives, I'm just wondering if the ICC has any rules on that, or if it doesn't have any bearing on, him possibly representing the former president.
But again, I would not want to speculate on a specific individual circumstances. The general rule is that, of course, the suspect may choose or can decide on who will be representing him or her. for the ICC, the person who would be a lead counsel for the defense of a suspect has to be on the ICC list of counsel. And to be on this list of counsel, there is a set of conditions of experience, of integrity, and of capacity to work in the ICC official languages, so English and French. And if this specific individual is not on the list of counsel, then we need to see whether he can be admitted on it or not.
And then finally, sir, of course, we have, you currently have a detainee who is actually 80 years old. So we'd also like to know how the ICC also makes sure that their welfare is well taken care of. And also, as another final question, how important is this? How significant is this case for ICC?
Well, if we start with the last part first, why is the ICC existing? It is because serious crimes have been committed in different places in the world, and there has been no accountability for these crimes. Because if there is a national legal proceeding against the same person for the same alleged illegal conduct, then of course the ICC is a court of last resort and will not be dealing with these cases. So the ICC is dealing with cases because there are victims who are still waiting to see justice and to know the truth and to see eventually people who might be responsible facing justice and making sure that there is a mechanism of accountability that is responding to the victims' expectations. And because of that, we consider that all cases before the ICC are very serious and very important, because in all of them, we have a duty towards the victims to try as much as possible to make sure that the truth is revealed, and that if a person is responsible, then he is or she is punished, and if he is innocent, then this is clarified for everyone. This is why all cases are important, because all cases are related to victims and to crimes that have remained unpunished until this moment. So it's not specific only to these cases, but all the cases before the court are considered of a grave nature and a very serious nature. Now, in addition to the first part of your question regarding the welfare, as a matter of principle, we do not communicate on the private aspects of the life of the detainees. We have to fully respect their right to the privacy. I can simply indicate that the courts puts all the necessary measures to ensure that the well-being, physical and psychological well-being of all the detainees is protected, that there is all what they might need on the medical level as well to ensure that during this detention period, they are protected and well taken care of.